to be heard. The respondents have not filed their responses. How will a matter proceed and the respondents have not filed their responses? A letter that we have annexed in the petition, the Supreme Court Registrar writes back to Sonko apologizing that, oh sorry, we apologize, we had not even looked at that this matter, respondents had not filed their matter. This is the Supreme Court apologizing and says we will give now new directions so that the respondents are given time to respond. That's ground 5. The 6th ground is that still after the Supreme Court apologizes to governor that this matter needs to respond, it goes ahead and fixes the matter for hearing regardless of them admitting that there is no responses by the respondents. Matter 7th ground. The Chief Justice, in a public function in the prayer day and on a radio station called Spice, comments on this matter and says very clearly that anybody who has been impeached stands impeached unless it is reversed. That was a matter that she was going to preside over. She makes a public utterance of a judgment before the real judgment is given. Governor Sonko files an application for her to recuse herself. That application for recusal is dismissed. Remember, Governor Sonko is alive to the fact that the question about a judicial officer raising her opinion or his opinion before the matter is before you for determination is so prejudicial to Governor Sonko. That was ignored. The application for recusal was rejected. The directions, number 8, comes that a 5-bench judge, we have given you a copy of the order by the Supreme Court that the matter for Governor Sonko will be heard by 5 judges. Court order is there. Come the date for hearing, there are 7 judges. The orders saying that there will be 5 order judges was never revoked. Governor Sonko and his team raised that question before the court. How can you tell us it is 5 judges by court order, then again you are sitting 7 judges? A greatest violation of the fundamental human rights of Governor Sonko was occasioned by that sitting. So the question we are raising, what prompted a full 7-bench judge when directions are issued that there are 5 judges? Still, number 8, after that has been done, this matter was filed way back in March at the Supreme Court. At the IEBC tribunal, it was rumored that Governor Sonko did not file an appeal. And it was a process that was being cooked within the registry until Governor Sonko produced Safaricom payment receipts, M-Pesa payment receipts, everything that was done online until the court agreed that he had filed within the timelines. 8, the decision in Mombasa is done on 12th, allowing Governor Sonko to be put in the ballot. On 13th, sorry. Immediately, the decision in Mombasa that put Sonko in the ballot, the Supreme Court immediately issues a hearing notice for 14. This matter was before the Supreme Court way back from March this year. It had never moved. But the decision of the Mombasa Free Judge Bench jolted the Supreme Court to react. Firefighting slotted the hearing on 14th. The duration as to why this matter was never determined from March to the 13th of July raises serious fundamental questions. Point number 9, the Supreme Court on 14th proceeds now to hear this matter. Serious protestations from the councils defending Sonko. This matter, directions have not been issued, respondents have not responded, and also, even if they respond, Governor Sonko must be given the right for a rejoinder. That was denied. Governor Sonko's petition proceeds on 14th, and a judgment, a ruling is issued same day, next day. What was the urgency? What was the urgency in this matter? The urgency of this matter, our client instructs us to say, and we are without a blink of an eye, that the speed at which the Supreme Court decided this matter was purely for politics, to stop Governor Sonko from being the ballot. He reads malice, he reads political machinations, he reads a lot of forgery and a lot of issues within that decision. Point number 11. Based with these facts, are they violations of his fundamental human rights? Article 38, which provides of the Constitution, which provides for the political rights, have been buttressed by Article 2, sub-Article 6, that says any treaty or any convention signed by Kenya becomes a law of this country. Therefore, we have gone to seek justice in the East African Court of Justice, which, from President, Senior Counsel, Her Excellency Mother Karua, when aggrieved with the decision of the Supreme Court because of not being a fair hearing, went to the East African Court of Justice, and the Supreme Court, by extension, the Kenyan government, was found to have flouted the fundamental human rights, Mother Karua. Therefore, we have a president, and that is why we are going to that direction. The last issue, the judgment, the ruling of the Supreme Court, which has never happened anywhere. The Supreme Court admits in writing that that matter, they had no jurisdiction. Everybody will read that. The Supreme Court has admitted it has no jurisdiction. Yet it goes ahead to hear and issue draconian orders. Every law student knows very well, jurisdiction is what confers a court power to proceed. The question of jurisdiction is admitted. They don't have jurisdiction. Therefore, what is the basis of these other orders? Because they could have ended at that point. So, Governor Sonko has gone to the East African Court of Justice to demand that a court without jurisdiction cannot issue orders at all. Appeal, a preliminary objection on jurisdiction compromises a matter in total. You can't move a step. How did the Supreme Court move ahead to hear this matter? If there is anybody that has been his rights have been violated completely, is one Governor Sonko. Remember, the decision of the Supreme Court, if it is upheld, it is a permanent imprisonment for Sonko, that he can never hold any public office till he dies. probably can go to get another public office in heaven. But in this world, he can't. It is such a grave question. It is not a light matter that destroying one's career permanently. Governor Sonko does not know any other profession other than the profession of politics. So that is why we have decided that we will move to the East African Court of Justice. Still, there are more layers. The international arena has very many courts that will get reprieve because this is about a career. And unless the Supreme Court is checked on this matter, we are not going to agree. Remember, the Supreme Court did not vacate the orders of the 3 bench judges at the High Court in Mombasa that allowed Governor Sonko to be in the ballot. What right now, as we stand here, this is a candidate for the Mombasa gubernatorial seat. We have launched a review at the Supreme Court. We have also launched a matter in the East African Court of Justice. What does Article 99(3)(4) say? That only will Mike Sonko be stopped from being in the ballot if all avenues of appeal have been exhausted. The appeals include review. That IEBC should take that judicial notice that still there is a review in the Supreme Court. There is an appeal in the East African Court of Justice. He cannot be stopped from being in the ballot until the review decision comes out and the appeal decision comes out, making him not be available. We strongly believe the East African Court of Justice will not be manipulated to sit and make that decision tomorrow, because that is a court that encompasses every aspect of the region. Sonko, as he stands here, is leaving now to go and campaign, and he leaves his legal team to battle with the issues that we have raised. So remember, we have only highlighted 13 grounds. The petition has more than 30 grounds on which he has put across that shows clearly that Sonko is being politically harassed. Reason being that he came to Nairobi to campaign, and he has been in Mombasa to campaign for the Azimio wing of the political arena. Let this serve as notice that Governor Sonko and all his team are prepared to ensure that no any other Kenyan will face the type of vilification and the type of hounding that Governor Sonko has been exposed to, simply because he has a different opinion. He should also be protected under the law. The Constitution provides in Article 27 for equal protection for everybody, whether a foreigner, whether a former governor, or a candidate in the governor's seat. So those are the instructions we have from Mr. Sonko, Governor Sonko. He will not be able to talk. He's completely overwhelmed of why are these matters taking this time. We can take 2-3 questions from the members of the press. The legal team will be able to answer. I want to finish this before I move to the last one. Okay.
We still have a decision by a 3-judge bench in Mombasa, which has not been overturned. Does that affect the candidature of the government?
That is what we are saying. The 3-bench judge has a judgment, a decision that has allowed the governor to be there. That judgment, that decision can only be challenged, and that decision cannot hold water if there is a decision vacating it by the 3 judges. The question before the Supreme Court, and this is what I want to differentiate, the question before the Supreme Court was not a question whether he should be in the IEBC ballot paper. That question was at the Mombasa High Court. If anybody is aggrieved with that specific question, it has not been dealt. Read the judgment of the Supreme Court. Nowhere have they issued orders for Governor Sonko not to be in the ballot. You cannot read what is not in the judgment. The judgment and the ruling that is expressed is the Mombasa ruling that has ordered IEBC to clear Sonko, and they have done that. So any reading, we've seen some media briefing that one Chebukati is going to read and give an opinion. It is not about his opinion. It is that there is a court order expressed to allow Governor Sonko to be in the ballot. And already, as we have said, we have gone for a review and we have gone for an appeal. Therefore, the hands of IEBC will be clear. If they will, at last, if we fail in all these avenues, that can only be an election petition ground when Governor Sonko will have been sworn in as the governor of Mombasa, and we will deal with the question of an election petition based on any other decision other than the provisions provided for removal of a governor. Lastly, for the benefit of the fourth estate and the country, we have instructions, very express instructions, to file a petition to JSC for removal of the CJ and any other judge who was involved in condonation of the abuse of the process. By close of business today, we shall have filed that petition for removal as provided for under the law. There's no malice about it. We have instructions from our client that we should also pursue this matter administratively to the Judicial Service Commission. Any other issue?
Thank you.
Thank you very much, and God bless you.
Manzo.
Oh, yes. Mheshimiwa, can you say something? Sorry. Mheshimiwa, can you say something?
On behalf of Wiper Party, where Governor Sonko is a candidate, we are not pleased at all by what has happened in the court. We do not condemn the court decision, but we do not agree with it. We are pursuing review, and we support the cause in the South African Court of Justice. It is surprising that politics have interfered with this, and the truth of the matter is the processes were not complied with. And for that matter, a review should lie, the whole matter should be looked at fresh, and then person who have participated in the interference should be dealt with by the law. So as a party, we shall protect our candidate, Governor Sonko, to the end. I thank you.
Lady Advocate, let us also hear the voice of the Lady Advocate.
We have moved to the East African Court of Justice because the East African Court of Justice has original and inherent jurisdiction to hear the matter that will be placed before it, where we are saying, by virtue of instructions by our client Governor Sonko, that his fundamental rights and political freedoms have been infringed and have been curtailed by the decision that was made by the Supreme Court of Kenya, which decision we have seen was delivered within 24 hours of ruling. It is also important to note that in the proceedings before the Supreme Court of Justice, there was no directions on submissions, which then curtailed the right of our client, the right of fair hearing, which is accorded and protected by the Constitution of Kenya. Therefore, we are hoping that in the fullness of time, and hopefully in time for the elections that are forthcoming in the next month, that we will see justice, and we will see the court of the East African Court of Justice upholding due process and legalities which have been protected by the Constitution of Kenya.
just to add on one of the ground that we have moved to the court, we have challenged the conduct of judicial officers. World over, there are principles that guides operations and conduct of judicial officers, judges, magistrates, and other officers included. These are Bangalore principles on the conduct of judicial officers. It is our instructions that the conduct of the judicial officers who handle this matter, one, they do not uphold equality of all parties that appears before it. Two, they did not uphold integrity of the system, integrity of the parties, integrity of every aspect of our client's case. Three, they did not uphold proportionality and equality of parties. It is a requirement that judicial officers who are hearing cases should give a fair chance to all parties, and they should not appear to have a predetermined position to the cases that are before them. This we have laid bare in our petition, and we are requesting and we are asking the courts within the region, being the East African Court of Justice, to intervene as to the conduct of the judicial officers who are involved since the matter was instituted in High Court to the apex, being the Supreme Court of Kenya. So we are hopeful that the correct action will be taken. Fundamental rights and freedoms of every individual are protected, not only in Kenya, but also world over. There exist statutes, there exist legal provisions that protects the rights of all individuals. So we are asking the court, let those rights be protected. Political rights are part of the rights that are protected. Let them be protected so that if you have to arrive at a decision that impacts permanently, otherwise to an individual, let them be heard, let them defend themselves, let the accusers face them, let them cross-examine, let them face the accusers to the ultimate, so that the decision and determination equitable to all parties can be arrived at. Thank you so much.
A new development. A new development on social media. My advocates have told me that IEBC has issued a revocation letter just now. True or not true, we will verify. They have not been served with this petition. From here, we are moving to advisory towers and serve them with the appeal and the review, so that whatever they are doing, as you have seen, the decision was on Friday. IEBC has sat within 2 hours on Monday. They are revoking with an anticipation that we will not have filed our papers. So we shall be moving with a petition to the IEBC and serve them that this is the true position. For now, there is an appeal and a review that is waiting. So I hope they are watching, and in the next 20 minutes, we shall be at the IEBC offices to serve them with the appeal.